let's jump to the next program, which is a debate program with, I'll introduce the moderator, LISA2022, who if you haven't figured it out, was also very instrumental in putting together this type of format. So if it works, it was my idea. If it doesn't work, it was his. But please also use, if you have questions for both the proponents and the people against the proposition, please put them in the app. Thank you.
Good morning. Let me see. Good morning. So you know. Hopefully you can hear me. Good morning. Thanks, Don. I'm LISA2022. I'm a partner at Hughes, Hubbard, and Reed, and I am going to be moderating this first debate. Before I get to presenting everyone who is here, let me give you a sense of the format as to that we will be following. I'm just going to give a very brief introduction, setting up what the debate is. Then each party for the proposition and against the proposition will make 15-minute opening statements. Then there will be a 10-minute rebuttal. After that, there's going to be a 10-minute question period done by a University of Miami student. And then after that, there'll be a 15-minute kind of round table discussion where we will also accept questions from the public. It would be best if you can go into the app and, you know, there's a place under debate one where you can present your questions. So that way, and that's the reason I have this thing here. I don't know if I can figure it out, but there'll be questions here, and maybe we can then include that in our is that better?
Yes.
Okay, thanks. And so that is the format that we will be following. I'm going to now present the speakers. However, first and foremost, each of the debaters here, and by the way, me too, have been assigned their role. The fact that they are arguing either for or against the proposition does not mean that that is their actual proposition. This is an academic exercise. This is meant for didactic purposes. The views they are arguing are not necessarily their own or that of their firms. So that should not be held against them. So let's start. The debate that we're going to have is whether dual nationals are appropriate claimants in ISDS. And as Claudia very nicely commented on me, that's, you know, specifically we're talking about when the issue of dual nationals are not specifically regulated by the applicable treaty. We are, you know, we are very lucky. We have a tremendous group. I am not going to go into depth into their bios. I'm going to go very quickly. Let me start here with my friend David Orta, who recently moved back to Miami.
I did.
Kind of like with Mario Cristobal. I hope you're going to do better than Mario. But he is the chair of the U.S. and International Arbitration Practice and the Latin American International Arbitration Practice for Quinn Emanuel. And yes, he's handled lots of cases. The next person really doesn't need any introduction. In fact, I think that's why he's wearing a mask, because he has so many fans that he, you know, he's trying to go incognito. We have David Rivkin, who has served as co-chair of Debevoise and Plimpton's International Dispute Program for over 20 years. He's been the past president of the IBA. He was appointed by the U.S. State and Commerce Departments to be a founding member of NAFTA, of the NAFTA Advisory Committee. Again, we don't need to go further. Against the proposition, we have Claudia Annacker, who joins us from Paris, from Dechert, where, of course, she focuses on public international law, in particular investor-state disputes, interstate disputes, and disputes involving international organizations and human rights. She, again, she's a represented states, and you can go to the bio. And then finally, Maria Lucia Echandia, who is really going to put everyone to their paces because she is not an old fossil. She is, young, and she is working here in Miami at Hogan Lovells, where she represents clients, dealing with ICSID, ICR, ICC, and under UNCITRAL. Let's go to the dispute. 3 very recent cases involving Venezuela have revived a debate that many had considered settled years ago. You have the Fraiz Trapote versus Venezuela case that was decided in January of this year. You have Enrique Jorge Hinson against Venezuela, decided October 2019, and Manuel Garcia Armas and various others against Venezuela from December 2019. Each of these cases, although using somewhat different reasoning, came to the conclusion that although the BITs involved, the Spain-Venezuela BIT and the Germany-Venezuela BIT, even though those BITs made no reference and consequently did not explicitly prohibit the protection to dual nationals, nonetheless, they viewed that the doctrine of dominant and effective nationality is an applicable principle of international law, really a construct of customary international law, that is applicable to the term investor, and that such dual national can only invoke the protections of the treaty against the country that is not his dominant and effective nationality. These cases stand in opposition to, I think, a pretty long line of cases in which the doctrine of dominant and effective nationality has been rejected as a defense of jurisdiction. These are involving Venezuela, Serafín García Armas against Venezuela from December 2014, Pei Casado versus Chile, May 2008, Oosterhentel versus the Slovak Republic, April 2010, Savafakis versus Turkey, July 2010, Bagat versus Egypt, November 2017, most recently Pugachev versus Russia, June 2020. Although these issues are going to be dealt with at greater depth and debate, it bears mentioning that the concept of diplomatic and effective nationality arises out of the context of diplomatic protection, particularly coming from the early 20th century, where the concept of dual nationals was disfavored. Let's put this in a very concrete terms. In about 1960, less than 1/3 of the countries recognized dual nationals. By 2018, over 75% of countries recognize dual and multiple nationalities. This is a dramatic sea change over the past century regarding the rights conferred to individuals. The case of Savafakis really puts the issue, I think, very clearly. It rejected the attempt to import the test into then investor-state arbitration context, explaining that treaties for the promotion and protection of investments, as well as the ICSID Convention, establish a separate mechanism of direct recourse to international arbitration against the host state. The rules of customary international law applicable in the context of diplomatic protection do not apply as such to investor-state arbitration. That is the question that is posed. I believe that we're going to start now with 15 minutes, and David Orta, gets to make the opening statement in favor of the proposition. David, you're on the clock. And by the way, I will try not to be too much of a hot bench, but I would hope to give a little bit of pushback to each one of the speakers during their presentation. David.
Terrific. Well, Thank you, Luis, for the introduction, and good morning, everyone. As Luis mentioned, David and I are going to be arguing in favor of the proposition, and I'd ask a few things of the audience. Number one, when you vote, please do not vote on the basis of who is better dressed, because obviously we would lose. So don't issue your vote on that basis, and keep an open mind. That's the other thing I would ask. All right. So the question before us is, in a circumstance where the BIT is silent on the issue of dual nationality, in that circumstance, should dual nationals be allowed to bring claims against a state of which they are also nationals? And what I hope to do in the 15 minutes or so that we have is to give you some guiding principles as to how that issue should be analyzed and why it is our view that the answer to the question should be yes, they should be allowed to bring claims against dual nationals. First of all, the question of whether dual nationals can bring claims against a state of their own nationality is not something that is regulated, generally speaking, by public international law. What do I mean by that? There is no general principle of public international law that prohibits dual nationals from bringing claims against a state of their own nationality. The ICSID Convention has a particular provision that does prohibit dual nationals from bringing claims against a state of their own nationality, but that is because the convention in Article 25 has a prohibition on dual nationals bringing claims against a state of their own nationality. But that particular prohibition within the ICSID Convention doesn't extend to investor-state disputes that are not brought pursuant to the ICSID Convention. Obviously, if a party brings a claim and chooses to file their dispute under the ICSID rules and convention, well, then they are aware and they've consented to having that prohibition apply in their dispute. But if they haven't, then the question is, and here is really guiding principle number one, what does the treaty say on the issue of who can bring a claim against one of the contracting states? And it could be a bilateral investment treaty, it could be a free trade agreement, or any other kind of investment agreement between two countries or more than two countries. And in order to answer that question, I think one of the key factors to look at is, well, how did the contracting parties to the particular investment agreement at issue define the question of nationality? And if we look at the definition of nationality and investor under most treaties, what we see is that in a large number of treaties, the issue of who is a national and who is an investor is, generally speaking, defined based on the laws of the different contracting states that are at issue. So if, for example, you have a treaty between the Republic of Georgia and the United States, and the two countries defined nationals based on, for example, one is a national of the United States if you're a national based on the laws of the United States. And similarly, one is a national of the Republic of Georgia if you are a national under the laws of the Republic of Georgia. And this treaty then says that a national defined in that way can bring claims against the other contracting state to the investment agreement. The tribunal should look to that definition and apply it based on, as we all know, the principles of treaty interpretation based on the Vienna Convention of Law Treaties. And when we look at the various cases that have looked at the issue of whether dual nationals can bring claims against countries of their own nationality, including the ones that have found that under the particular analysis of the treaty at issue, they could not do so. In other words, the dual national could not advance a claim against the country of which they are nationals. Again, the guiding principle is what is the language in the treaty and what does it say? As opposed to what do we think is right or wrong, as opposed to whether the arbitrators in the particular dispute have a particular belief about whether nationals should be able to sue their own countries based on investment treaties. Those considerations shouldn't play a part.
David, can I push back just a little bit on that?
You can try.
I can try. The whole purpose of investment dispute is a foreign national comes and invests in a country, that country goes ahead and expropriates or violates, some rights. And so treaties are created there to protect the foreign nationals. People who are citizens of that host country don't get the benefit of that. They have to go through their own judiciary. Investment state is not meant for someone who is a citizen of the host country. So now you have someone who has been living in some Latin American country, their families have been living there for 100 years, but because their grandfather or whatever was from Spain, they now have Spanish citizenship. Why should that person be able to go ahead and say, well, I'm a Spanish citizen? That person is really a member of that state. They're suing their own country. Is that really the purpose that we're trying to follow here?
Well, I would challenge the premise that you laid out. You said in your comment that these treaties were designed with the purpose of only allowing foreign nationals to bring claims against another country, right? And I challenge that premise, right? In other words, the premise itself that a foreign national can bring a claim against another country is, by itself, is fine. But the subsequent premise in your question, which is, but if you also have the nationality of the state against whom you're bringing a claim, then you shouldn't be allowed to bring that claim. And my answer is, if that's what the contracting states to an investment treaty want to do, then they can write that prohibition into the treaty. And when you look at, basically what the treaty practice between various countries and sort of the evolution of that, one sees that there are a number of countries that have treaties like the one that we're discussing in the context of our debate here, where the contracting parties are silent on the prohibition of dual nationals bringing claims against their own country, but where, for example, in other treaties negotiated by the very same countries, they've included restrictions. And if we look, for example, at U.S. treaty practice and what the United States has done, there are a number of treaties where the United States has included some form of restriction on nationals bringing claims against their own country. Look at the USMCA, all right, which was recently negotiated. Look at NAFTA, and look at the difference between the two. In NAFTA, you have the United States, Mexico, and Canada negotiating a treaty where there is no limitation placed on dual nationals bringing claims against, a country of their own nationality. And in fact, in NAFTA, the three contracting states allowed permanent residents the same status as basically nationals for purposes of advancing claims against their country. In the USMCA, there is the possibility for dual nationals to bring claims against a country, one of the contracting states, so long as they can establish that their dominant and effective nationality is the nationality of the state from which the investment, the outbound investment is coming. So I challenge the premise, and this is why I said at the beginning that our conception, an arbitrator's conception of what these treaties, what their purpose was or is not really what should be deciding the case. What should be deciding the case is, what do the treaties say? And it's a very simple thing for countries and governments when they're negotiating these treaties to include prohibitions on dual nationals bringing claims. It's very simple to write that into the treaty. The other point is, when we look at the cases, even again, the Venezuela cases that have come out against the proposition, okay? What we see is the arbitrators are doing their best, I think, to try to interpret the treaty language and the treaty language based on the object and purpose of the treaty. On the issue of is the treaty supposed to be encouraging foreign investment? Well, that's an interesting question, right? Because one could look at it that way. One could also look at it as saying the treaty's aim is to encourage investment in the country, as opposed to foreign investment in the country. So I think the premise to the question is false. On the issue of whether dominant and effective nationality should play into this, you, in your introduction, raised the notion that dominant and effective nationality is a principle of public international law, of diplomatic protection, and that therefore some arbitration tribunals have included that particular limitation into this discussion of whether dual nationals can bring claims against their own country. There, I think that, again, if a country or if countries that negotiate these treaties want to include that limitation, then they should, just as the United States did in the USMCA, just as the United States and other countries did in the context of DR-CAFTA. There's a particular provision in DR-CAFTA where the countries said a dual national can bring a claim so long as they can establish that the dominant and effective nationality that they have is of the state from where the investment is coming from. So just to sum up, I think the guiding principle should be, what is it that the treaty says? What did the contracting states to the investment instrument at issue say with respect to the issue of dual nationality? If they didn't put an explicit exclusion in or a limitation such as the dominant effective nationality, I don't think that the right analysis is to say the treaty is silent on the issue. No, the treaty speaks to the issue, and it speaks to it in the context of the definition of who is an investor and who is a national. And if the states have decided to give a very broad definition to the concept of investor, and the only limitation they have placed in the context of who is a national is what does the law of the state say as to who is a national, then that's what should be applied, and not some other conception about whether persons should or shouldn't be able to, and when I say persons, I mean both natural persons and juridical persons, whether they should have the ability to bring claims against a country of whom they also share a nationality.
Thanks. And you came in 30 seconds under. I challenge everyone here to do that. Todavía? Hello? Oh. Do I have to go rock star like Gonzalo? Okay. Claudia, I think you get to provide the opening statement for those who do not believe, who are against this proposition. And you have the floor.
Thank you, Louis. So our proposition is an investment treaty that is silent on dual nationality, does not protect individuals who hold the nationality of both contracting parties. Now, this follows first from the ordinary meaning of the investor definition, properly read in its context, including the investor state arbitration clause itself and the treaty's substantive protections. Now, these protections make clear that the entire treaty is indeed based on the idea that the investor does not have the nationality of the host state. Now, investor definitions typically qualify an individual as an investor protected under the treaty if he or she is a national of a contracting state or one contracting state under that state's applicable domestic law. Now, the term investor, as defined in the investor definition, is then typically used throughout the treaty in direct juxtaposition. So is an investor of one contracting party on the one hand and the other contracting party on the other. Now, the investor state arbitration clauses allow investors to submit to arbitration disputes between one contracting party and an investor of the other contracting party. They are making clear that the contracting states do not consent to arbitrate disputes involving their own nationals. Investment definitions, they likewise refer to investments made by an investor of one contracting party in the territory of the other contracting party. And this juxtaposition also permeates the substantive protections of investment treaties. Now, to take one example, national treatment clauses. National treatment clauses require each contracting state to accord to investors of the other contracting state and their investments treatment no less favorable than that the state accords to its own nationals. Now, this clause evidently presumes diversity of nationality. If that clause is applied to dual nationals, then it would allow the host state's own citizens to bring international claims on the basis that they were treated less favorably than their fellow citizens. Now, according investment treaty protection would also be, to dual nationals, would also be hardly compatible with the object and purpose of investment treaties. The object and purpose of investment treaties as expressed in their preambles. The contracting states to an investment treaty confer rights and remedies on foreign investors that are unavailable to their own citizens. And they do so to attract foreign capital, and specifically capital of nationals of the other contracting state. Now,
Can I
contribution,
can
can
I-
I just finish that thought for a second and then
Yes.
I will read it. A contribution of capital to the host state's economy by a national of the other contracting state is indeed the quid pro quo for an investor's right to invoke investment treaty protection and the right to arbitrate. So this quid pro quo is fundamental to the architecture of an investment treaty.
And you said that much more artfully than when I asked the question to David. But David's response was, and indeed, you have come in and started talking, well, the definition of a national and going. And David's response, which I think is more than reasonable, says there are many treaties that specifically address the issue of dual national. The moment you don't address that, you are now, bringing something else that's not in the treaty. And let me go a little bit further. A friend of mine, Andrés Mejiravi, is publishing an article on this issue the next month, and one of the things he brings out in that article is, he goes, being a national of a state is a human right. You get a bundle of rights by being a citizen of that state, and that state gets to decide who is it. Aren't you denying, someone's rights as a citizen of another country and denying them the protection of that, of being the national of that country, simply because, again, that person happens to be a dual national? And being a dual national, as I said earlier on, 75% of the countries today recognize dual and multiple nationals. Hasn't that concept changed such that if really you want to go ahead and deny dual nationals, put it in your treaty. And if it's not there, amend it.
I think there's still a relatively small number of investment treaties that actually contains express prohibitions for dual nationals to bring claim, or to actually the often position is that only the dominant and effective nationality is the one that should be considered for purposes of bringing a claim under an investment treaty. So the question is whether states can really be deemed under all the other treaties to have granted investment treaty protection to their own nationals. The ICSID Convention makes it crystal clear and expressly and categorically requires diversity of nationality. Now, I do submit that this express limitation it actually reflects a consensus in international investment law.
Let me stop you right there. ICSID Rule 25 says that a dual national at the time of registration of the claim, or the time consent is made, is barred. But you could be a dual national when the investment is made, and then, just prior to consenting, you go ahead and revoke your nationality. ICSID doesn't say dual nationals aren't entitled to protection. It simply says if you're a dual national at the time of the registration. That's different, is it not?
I think that's a natural consequence of the procedural nature of the ICSID Convention. That the ICSID Convention could not include rules concerning the substantive protections in the nationality requirements at the time of the breach of an investment treaty. Now, maybe I go on with the next issue because it directly addresses the question whether you need to address an exclusion expressly, and we submit that you don't. Now, why is this the case? In addition to the structure of the investment treaties and to the object and purpose that we submit very much supports that states have the intention not to protect dual nationals unless they expressly address that topic in the investment treaty, is that this approach is also fully in line with customary international law. It is a basic principle of customary international law inherent in the principle of sovereign equality of states, that an individual cannot bring international claims against their own state. Now, this principle also precludes international claims by dual nationals against one of their states of nationality. And under customary international law, the sole exception is if a dual national's dominant and effective nationality is that of the other state. Now, if a treaty is silent on an important principle of customary international law, then the contracting states cannot be deemed to have tacitly dispensed with such a principle. Now, this has been confirmed by the International Court of Justice, by the Erroneous Claims Tribunal, and by investment treaty tribunals. The prohibition that individuals may not assert international claims against their own states is such an important principle. And it can therefore not be dispensed with tacitly. It must be dispensed with expressly. Moreover, investment treaties are not self-contained regimes. Self-contained regimes that would operate in clinical isolation from general international law. So pursuant to the principle of systemic integration as enshrined in Article 31, paragraph 3c of the Vienna Convention, the requirement of diverse nationality under customary international law must be taken into account. It must be taken into account as a rule of international law applicable in the relations between the contracting parties to an investment treaty.
And let me just stop you there, and I don't want to take up too much of your time, but you say, you know, customary international law. At my introduction, I talked about 6 or 7 cases that apparently don't feel it's customary international law to really impose the dominant and effective nationality. They thought that it's perfectly fine. How can you really say that it is the customary international law? You know, I go back to the 1930 convention, relating to conflicts of nationality, which in its preamble says, we don't believe in dual nationals. We don't want it. And so, then the treaty goes on to affect that. Only 20 countries signed that in over basically 100 years. Can you really say it's customary international law?
I believe it's firmly established customary international law that a citizen may not sue its own state on the international plane. Yeah? And you have already by the International Court of Justice, even the predecessor PCIJ, they have established that more firmly. Most recently, within the UN International Law Commission, you have that rule confirmed in the ILC's draft articles on diplomatic protection. So
which has not been adopted by anyone.
So far, it's under active consideration by the UN Sixth Committee, and I'm not aware of substantial opposition. In particular, I'm not aware of opposition against the rule that a state may not exercise diplomatic protection in the case of dual nationals, unless the dual national has the dominant and effective nationality of that state. So let me conclude with some reasons. We think that there are indeed compelling reasons for not according dual nationals investment treaty protection. So first, permitting dual nationals to bring investment treaty claims simply because the treaty contains no express prohibition would lead to bizarre results. It would lead to the bizarre result that dual nationals could bring claims against either contracting party or both. It would also open the doors, permitting dual nationals to opportunistically invoke protections that are designed to protect foreigners and at the same time benefit from rights reserved to citizens. Now, investment tribunals have emphasized nationality is a two-sided coin. On the one hand, it grants rights to its nationals, but on the other hand, it imposes obligations on them, including obligations that could not be imposed on foreigners. So according investment treaty protection to dual nationals would allow dual nationals claiming to be citizens of the host state to obtain the benefits of the citizenship, and at the same time to be foreigners to obtain the benefits of of treaty protection. Indeed, dual nationals could even rely on the host state's nationality to avoid restrictions and admission requirements applicable to foreign investors. Now, having made their investments, they could then rely on the nationality of the other contracting state to invoke investment treaty protection against the host state. So we submit that it is necessary to avoid opportunistic invocation of investment treaty protection against host states to exclude dual nationals. The host states should not be exposed to investment treaty protection being invoked as both a shield and a sword, and dual nationals should not be allowed to have it both ways. Thank you.
Thank you, Claudia. David?
Thank you.
You have the floor.
Thank you. It's a pleasure to speak in favor of the proposition on behalf of Team David, or as Luis put it, the team of old fossils. By the way,
Which did not get the memo about the no ties. But okay, I'm not.
it's part of being an old fossil to wear a tie. And by the way, I'm wearing a mask because, for a very happy reason, our daughter is due to give birth on Thursday in Washington, and we're going to be there, and we want to make sure we're protecting ourselves. In any event, let me make a few arguments in response to Claudia's very well stated arguments and the other arguments that we've heard. First, let me begin with a core proposition, and that is that international law recognizes the right to nationality and indeed the right to dual nationality. So in our view, any derogation from that right should be explicitly stated. That is a fundamental right of people around the world. So there needs to be, if there were to be a derogation, it ought to be clear. And in fact, as has already been pointed out, there is no blanket prohibition on dual nationals to file claims against a state, one of the states of nationality under a treaty. We know that Article 31 of the Vienna Convention on the Law of Treaties says you first look to the text of a treaty. And the text is the first and most important source of interpretation. And again, the text in the treaty we are dealing with in this hypothetical has no prohibition on dual nationals. The very general language on investors that Claudia mentioned, in fact, I think points the opposite direction. It simply says investors of one state can bring a claim. So a dual national is an investor of one state bringing a claim against the other contracting state. And again, if the parties to that treaty wished to make it clear that that state couldn't be a state where the investor also happens to be a national, they could have so stated, and they chose not to do so. The fact that many treaties do have explicit prohibitions against dual nationals shows that these states didn't view these broad provisions on the definition of an investor to be sufficient in order to rule out dual nationals. So I think that those provisions, in fact, work the other way. So when you have a treaty that, like the one in discussion here, that is silent, the plain text under the Vienna Convention, Rule 31, Article 31, certainly leads towards the acceptance of dual nationals, and certainly cases like the Serafin Garcia Armas and Rawat versus Mauritius made that particularly clear. And indeed, I think that is completely consistent with the other provisions of the Vienna Convention to look to the object and purpose. I would argue, as David did, that the purpose of a treaty is to promote investment, and that's why the states have entered into it. Limiting protections to non-dual nationals would limit the purpose of that treaty to create more investment in the host state. And indeed, once again, if the host state wanted to limit that investment protection, it could have chosen to do so. And again, the Serafin Garcia Arma's case makes that point very clearly. Then let's turn to the customary international law arguments. First of all, I think it's quite clear that in entering into bilateral investment treaties, states have chosen to create a lex specialis. They have created a very specific regime designed to deal with certain investments and offering certain protections. They've chose not to rely upon broad principles of customary international law that existed over years. They created a specific investment regime. That doesn't mean, of course, that customary international law isn't sometimes applicable to interpreting provisions, but again, where you have a definition or a lack of definition here, it needs to be considered. And particularly when you look at the customary international law that's relied upon, it all derives from diplomatic protection. The whole point of bilateral investment treaties was not to rely on diplomatic protection, to give investors rights that they didn't have under the regime of diplomatic protection, to bring claims on their own. And the purpose of not having a state represented dual national in a diplomatic protection context is very different from an investor-state case. In a diplomatic protection situation, of course it makes sense that a state would not bring its own weight to bear to argue against the state where the investor also happens to be a state. That would create clear diplomatic problems. That's why this doctrine developed in the first place. That's very different from the context of investor-state cases, where instead the states have said, we don't want to be the ones bringing these claims. We want to leave it to the investors to bring those claims. And so it's simply a different regime that has to be considered differently. Similarly, again, the dominant and effective nationality test simply isn't stated in these treaties. David pointed out that, yes, it's been included in a couple of very recent treaties, but when the parties drafted these bilateral investment agreements, they knew that that was a part of customary international law, and they chose not to include it in the treaty.
Can I just ask you about that? In the most recent Venezuela case, the Farage case, the tribunal said the fact that it doesn't say anything doesn't go, doesn't push either way. And in fact, by its being silent, that's why we have to bring in the customary international law, which again looks to the dominant and effective nationality.
But you can't bring in customary international law that was developed for an entirely different purpose. And again, the customary international law on diplomatic protection was created for a very different purpose, to prevent states from effectively infringing on the right of another state by bringing diplomatic protection. The states created a very different regime here. So, yeah, so when you're looking at fair and equitable treatment, for example, the states purposely chose a very broad principle, and you can look beyond the treaty to find how to interpret that principle. But here, you look again to sources that would be consistent with the purpose of the fair and equitable treatment. Here, the customary international law derives from a very different purpose. And so similarly, I don't think you can rely upon the so-called exit import rule. Again, for a number of reasons. First of all, the states purposely chose to give investors a range of procedural options. Even in treaties where they said, well, first go to ICSID, but if ICSID's not available, go to there. They still made it clear that there was a range of procedural options, and the state therefore left itself open to claims brought under different regimes, different sets of rules, different jurisdictional requirements. So the states, having chosen that, you can't then impose one set of rules on an investor's selection of a different fora and a different set of rules. If you're going to take that approach, why not say, well, you know, even though they chose uncitral, there was a preference for ICSID, and even though they offered uncitral as an option, there was a preference for ICSID. So let's create an annulment committee on top of that, because that's what the states really wanted. That could be seen as jurisdictional in a sense, but that's not what they did. The states purposely left it to investors to choose from one set or another of procedural requirements and jurisdictional requirements. And again, if they wanted to exclude dual nationality, they could have. I think with that, let me close again by returning to some of the core principles. If dual nationals are protected under BITS, they're encouraged to invest their capital in one of their states of nationality. This would have positive impact on the host state as for foreign investments. We should not, Claudia mentioned towards the end that, well, that could mean that an investor relies upon being a citizen of one state and making the investment, but relies upon being a citizen of the other state in seeking certain protections. I think that, again, international law and the law created under ISDS has made clear that there can be abuse of process. It has created an opportunity for tribunals in the extreme cases to prevent that kind of a situation. But we shouldn't let the extreme case limit the core cases where that has not been done. So again, I want to return to the basic international law right to have dual nationalities, and if you're going to derogate from that right, the states should explicitly state in their treaty they have an ability to amend it if they want, but if they have not done so, their silence creates a right for dual nationals. So thank you for your attention, and happy to hear the counter-arguments from Maria Lucia. Thank you.
Thanks, David. And Maria Lucia, all I'm going to do is I'm going to anticipate my question to you. And so David goes on and points out that these BITs are lex specialis. You know, the countries have agreed to that as the law between them with respect to investments. And as he pointed out, the whole concept of BITs was meant to replace this concept of diplomatic protection. So how do you respond to that in terms of saying, no, we want to go ahead and follow customary international law and impose the doctrine of dominant and effective nationality? You can answer, you don't have to answer directly to that, you can do it within the context of your rebuttal.
Thank you, Luis, and I will get to your point, and thank you to the Miami International Arbitration Society for this wonderful event. Before we get into the lex specialis argument, I want to mention some things brought by David and David in their presentation, and specifically the reference to the interpretation of the treaty under the Vienna Convention. And while it is true that tribunals cannot add prohibitions or further restrict the jurisdiction of the tribunal, that is true if the treaty were to contain provisions regarding dual nationality. But here, we're under the assumption that the treaty is silent. And the problem with that premise is that it assumes that silence means consent. And that is an interpretation that cannot be derived after we apply the principles of the Vienna Convention. By looking at the preamble of the Vienna Convention, it recognizes that the law of treaty is enshrined in three main principles of international law. The first one being consent, good faith, and pacta sunt servanda principle. And if we limit ourselves to just looking at the consent principle, can we really say that a state has agreed to arbitrate a dispute with its own nationals under an investment treaty aimed to protect foreign investment? And the answer is no. Consent is the condition precedent to arbitration. Tribunals, arbitral tribunals, have limited jurisdiction, and in investment treaty law, that jurisdiction is limited by the state's consent. So nationality and foreign nationality here plays a key role, because foreign nationality is what allows investors to enforce the protections and the rights under a treaty. But the foreign nationality is also the link that allows tribunals to assert jurisdiction over a particular dispute. So if we apply the principles of the Vienna Convention, we cannot in good faith say that consent of the state is presumed simply because the treaty is silent. And if we go to Article 31, which was also mentioned, my colleagues talked a lot about the text of the treaty and the textual interpretation of the treaty. But that also has a problem, which is that you can't interpret a treaty outside the context of the treaty and without taking into consideration the purpose and the object of the treaty. And this was something that was reviewed by the Frey's Venezuela Tribunal this year. And the tribunal came to a conclusion that I think is very relevant. And it says that the purpose and the object of the treaty is the port of arrival. It is not the point of departure in treaty interpretation. And what this means is that when the Vienna Convention refers to the ordinary meaning of the terms, it's not referring to the literal meaning of the words, but how those words should be understood within the context and the purpose and the object of the treaty. And it was also mentioned here today that the purpose and object of the treaties, of investment treaties, is to protect investments. Well, I think that's a very broad definition of the purpose of what investment treaties are aimed to protect. Investment treaties are not aimed to give nationals an additional forum to resolve their disputes with their own states. And it is not a mechanism to circumvent the jurisdiction of local courts. The main purpose of investment treaties is to protect foreign investment. And again, the foreign nationality is the key and the link that holds those investors' rights and the tribunal's jurisdiction. So when we look at the interpretation provision of the Vienna Convention as a whole, excluding dual nationals stems from a good faith interpretation regarding the context of the treaty and the purpose and the object of the treaty. We also heard today that the prohibition of the ICSID Convention cannot be applied to other forums, that is restricted to ICSID. But this argument would also create an additional problem that cannot be overlooked. And what would the problem be? That an investor that brings a claim under ICSID would be barred from doing so if that investor has dual nationality and is suing its own state. The claim falls automatically outside the jurisdiction of the tribunal. And this prohibition is absolute, cannot be cured. But if that same investor brought the exact same claim against the state under the exact same treaty, the argument is that that claim should be allowed because there's no express prohibition. Then we would end up with two definitions of investor under the same treaty. And this is a result that is unsustainable in international law. And that would be the result if we were to say that just because there's no express prohibition under other forums, then the claim should move forward. And getting to your point, Luis, a lot has been said that treaties are lex specialis. They are. That is not something that can be denied. But as Claudia mentioned, they are not self-contained regimes. They cannot be applied in a vacuum, disassociated from principles of international law. And while it is true that the principles of dominant and effective nationality were born under the diplomatic protection regime, they have extended throughout the years to investment cases, and that has been widely recognized by the case law. So even if we can say that the starting point of the dominant and effective nationality was, in fact, diplomatic protection, it didn't stay there. It permeated other areas of international law, one of them being investment law. And even if the treaty doesn't say that you can apply principles of international law, the Vienna Convention, Article 31.3, does allow you to resort to principles of international law when the treaty does not rule on the subject. And here we are under the assumption that the treaty is silent on the issue. So resorting to rules of international law, including dominant and effective nationality, is what tribunals consider that is appropriate.
Well, and thank you for allowing me to interrupt you in mid-sentence. Let's go back to what David said, though. There is no blanket prohibition. And, if you're going to derogate someone's rights, if you're going to take away someone's rights as a national of a other country, shouldn't that be expressly stated?
I think those are two different things. You can have the right to be a national of a state, but that does not automatically give you a right to be an investor protected under a specific treaty that does not grant you that consent or that protection, because the state has not consented to resolve that dispute with you as a dual national. So it's not that I'm taking the right away of being a dual national, it's that I'm not including you within the consent, my consent of the state to arbitrate a dispute with you because you are also my national. So it's not an issue of taking the rights away. You are a dual national under international law, that's fine. But under the treaty, if I don't give you protection, I am not consenting to arbitrate the dispute with you. And I think those are two different issues that should not be treated the same way. And I think just to end, and I want to conclude with something that Claudia was mentioning, and is that dual nationality or nationality cannot be used to obtain all the protections under a treaty or all the protections that the state grants to its own nationals, but then use the foreign nationality to gain access to a forum that would have been otherwise unavailable to resolve a dispute that is purely domestic between a state and its own nationals. And that would be an abuse of rights on the investor, and it would also be a bad faith interpretation and application of the treaty under the Vienna Convention.
First of all, thank you for ending so early and trying to get us more time, but I'm going to defeat that by asking you, again, isn't that solved? Let's say you're saying it's an internal dispute. Well, what happens if the dual national revokes the citizenship, his or her citizenship of the country, the host country state? That person still lives in that host country state. He just revoked it, and now, even though the investment was done as a dual national, he still lives there. Now he's only, he's no longer a dual national because immediately prior to consenting, he revoked it. Doesn't that really go against the whole concept that you're circumventing the purpose of the treaty?
If you are renouncing your nationality prior to submitting your claim, that is an abuse of your right. Because if the sole reason why you're renouncing your nationality is to gain access to a forum that you would otherwise not have access to, and when you made your investment, you were a national of the state. Throughout the execution of your investment, you were a national of that state. If for the whole purpose of getting access to the forum, you are renouncing your nationality, that would be an abuse of rights as an investor. Same in the sense of, state or investors that acquire a nationality when they're about to file their claim in order to get protections under a treaty that they wouldn't otherwise not have.
Thanks. And by the way, exactly at 10 minutes. I think if there's a student from the University of Miami who has questions on this before we get, and we've gotten several questions from the people here. Is there? Yes.
Good morning. Hello, everybody. My name is Yesenia Alfonso. I'm a JD LL.M student in the International Arbitration Program. I do have one question. This is equally for all of the panelists. So in the hypothetical where you have a state-owned entity, and that state-owned entity might have dual nationality, should there be a presumption that the state that owns the entity is the national for the sake of the arbitration?
Yes, Anya, can you just clarify for me one more? So you're saying it's a state-owned entity?
Right, but they might have dual nationality. For example, let's say it's a company that's incorporated in a state other than the state that actually owns that company. So where should we be looking at in terms of determining nationality?
I see. So a local company, right? So you're saying it's a company that's incorporated in the state where the investment is made, but it may be controlled by a foreign.
Correct.
Okay.
Correct.
So, I mean, I think there, again, we look to the treaty, and we look to what did the contracting parties say with respect to that particular situation. And there are a number of treaties that have provisions that provide that if you have a local company that is basically the way in which the investment was channeled, okay? But that local company is owned and/or controlled by a foreign investor, an investor who is a national of the other contracting state, then for purposes of determining nationality in relation to the possibility of bringing a dispute under the treaty, the local company will be treated as a national, a juridical person of the other state. And there are a lot of provisions, a lot of treaties that have provisions just like that. And in fact, in the ICSID Convention, in Article 25, 2B, there's also a provision that allows for local companies that are foreign controlled to be treated as a national of the other state, provided that the two contracting states agreed to that.
Thanks. Okay, let's go to some of the questions that have been,
Luis, can I ask a question of our colleagues on the other side there?
Absolutely.
All right. I'm curious. So in the scenario that we're discussing where the treaty is silent, in other words, it doesn't have any prohibition on dual nationals bringing claims. In that particular circumstance, if let's say the national of the state, in your view, would persons who hold dual nationality then have no ability to bring claims against either country that's the subject to the treaty, if you understand my question? So let's say you have a Venezuelan national who also has dual Spanish nationality, okay? And let's say that Venezuelan national, their dominant and effective nationality is Venezuelan because they live in Venezuela and that's where they raise their family and that's where they have lived most of their lives, et cetera, et cetera. And let's say they make a very important investment in Spain. And let's say Spain expropriates that investment. Do they have a right to bring a claim against the Spanish government under the bilateral investment treaty between Spain and Venezuela?
The sole exception on our side, the proposition is if an investor has dual nationality, to be able to bring a claim would indeed be dominant and effective nationality. So the answer is no. There is no claim under an investment treaty if not even the requirement of dominant and effective nationality is met. And the reason for that is we've already discussed the structure of investment treaties, object and purpose of investment treaties, but I fundamentally disagree with the proposition that investment treaties are designed to promote and protect investment as such. No? They are not human rights treaties. They are specifically contracted with a foreign government in order to foster economic cooperation with that state and attract investment by nationals of that other contracting state. Yeah. And when it comes to investors with dual nationality who cannot sue under an investment treaty because they don't have dominant and effective nationality, they have their rights as citizens. In particular, there's the proper instrument to promote and protect such investments, if the government wants to do it, is domestic legislation. Domestic investment legislation often extends both to domestic and foreign investments, and of course there are even privileges, special rights that are conferred on domestic investors that are not conferred on foreign investors.
Wait, so in answer to my question, the answer is they can bring claims against Spain if their dominant and effective nationality is Venezuelan?
Correct.
Okay.
But only.
Only if. So dual nationals can bring claims against a country of their nationality so long as their dominant and effective nationality is the other. So we're importing into the treaty a limitation that's not there.
I think the example is because we know of cases that have already resolved the Venezuela and Spain issue, and the principle was imported. And I think that's why we're saying, if you're talking about that specific treaty of Venezuela and Spain, where we have 3 decisions that have repeatedly stated that the principle of effective, dominant and effective nationality principle should be applied, then that would be the result. But if we are basically basing it solely on the principles, if it were not a treaty that contained or that had case law that had interpreted that treaty in that way, I think we would still have to look at the consent and interpret the treaty as a whole, taking into account the context and what the states agreed to arbitrate.
I just want to make sure, are there any other questions from any students? Are there any additional questions? Camilo?
I was wondering if it wouldn't be seen as a potential breach of pacta sunt servanda by the tribunal itself when interpreting a treaty that doesn't expressly bar dual nationals from subscribing to a claim. So under the Vienna Convention of the Law of Treaties, wouldn't it be a stretch by that tribunal to interpret the nationality provision as going too far when barring a claim by a dual national?
I think that the pacta sunt servanda principle, what it does is protects what the parties have agreed to. And if the parties have not agreed to arbitrate claims with dual nationals, then there will not be a breach of the pacta sunt servanda. On the contrary, they would protect the state's consent not to arbitrate disputes that are not expressly contained in the treaty.
Okay, once more. In the case of dual nationality, there's 1 or 2 treaties that provide that in such situation, if the person in question has the effective and dominant nationality of the host state, this shall disqualify from bringing a claim against that state. But considering that or the consequence of that language is, I think, among other things, that this means that the language is meaningless and devoid of any sense if we accept that the general rule as a general proposition about effective and dominant nationality shall be applied also in the absence of such explicit language.
I think quite the contrary. There are lots of provisions in new generation treaties, and you find these exclusions, explicit exclusions in many new generation treaties that simply clarify existing investment treaties or that are codifying prevailing trends in investment arbitration. So I think that with these explicit clarifications that a claimant under an investment treaty needs to have dominant and effective nationality at least, the states are reacting to investment treaty jurisprudence, but they are doing it in a way to clarify, rather than allowing the conclusion that under the overwhelming majority of the treaties, they have already concluded they would like to protect dual nationals, even if they don't have dominant and effective nationality.
Again, there are several questions that have come in from the public through the app. Let's see if we can try to do these quickly. One says, would strengthening the obligation to pursue local remedies mitigate the concerns of allowing dual nationals to bring treaty claims?
I think that is something that in the international level, you can always recommend to states that they provide additional protections to their nationals, but the consent of the state or the rights to bring a claim under investment treaty law cannot depend on what the states locally decide or the protections that they locally decide to afford to their own nationals. And local legislation or generally have provisions against protection of expropriation and due process and other internal mechanisms that allow domestic investors to obtain protections under the treaty.
I would just say that that shows that, again, if states want to impose this kind of requirement, if they want to add more requirement to pursue local remedies to a treaty, they can do that. If they want to impose a dominant and effective nationality test, they can do so. So I think it just fits in with our theme.
A question comes in and says, some treaties were negotiated years ago when these discussions were not so developed. Should this be considered in the interpretation by the tribunal?
The short answer is no. I think that states are very sophisticated parties, and when they negotiate treaties with other countries, they have very sophisticated teams that are involved in the negotiations, and I think it's a very dangerous exercise to have a tribunal start to guess at what it was that the contracting parties were negotiating and what was in their minds or what was available in terms of knowledge to them at the time the treaties were negotiated. Even though, as we all know, these treaties started being negotiated, in the late 1960s going forward, and to presume, for example, that when the earlier treaties were negotiated, there was no understanding about the concept of dual nationality and how that might bear on, the language being negotiated by the different contracting states, is an exercise, I think, in peril. The concept of dual nationality has been around long before these treaties were negotiated.
Any comment, or can I go to the next question? Okay. If a person has the nationality of the host state is dealing with a national, can you apply international law to a national? It's really for your side.
Well, under the thesis of the debate, they're also a national of the other country. And once again, the host state has chosen in its treaty to define investors in a certain way, and to define them not in a certain way. And I know we have a disagreement as to how they've defined it, but I think that question just goes to the core of the debate. But in our view, for the purposes of this debate, that person is also a national of the other state.
Kind of following up on that, question is Team David advocating that silence is acceptance in the international realm?
I've been dying to take this point. No, Team David is not advocating that, because I think, again, there's a false premise. Silence equals consent. The contracting parties weren't silent. They made a definition of what a national is and what an investor is, and they agreed that a national is whatever the law of each of the host states, each of the contracting states, however they define nationality, that is what a national is for purposes of the treaty. So I reject the notion that there's silence. No, they've spoken as to who a national is and who an investor is, and the entire premise of Team David's argument is we should not be importing other restrictions or limitations into the treaty when the host states or the contracting states didn't themselves put those limitations in the treaty.
I would just add that I thank the questioner for referring to us as Team David and not Team Old Fossil.
We have a couple more minutes. Any impact in the discussion if the dual nationality was in place before an incumbent bid was entered into? I think it's for...
I'm sorry, can you repeat that?
Any impact in the discussion if the dual nationality was in place before the incumbent bid was entered into? So there was dual national, and then the bid was entered into. Does that impact the fact that...
I think you have to see when the investment was made. So was the investment made while the treaty was already in force, or was the investment made prior to the entry of the treaty in force, because if it was made prior to the treaty, then it's not protected under the treaty. And if it was made while the treaty was already enforced, then the dual nationality restriction will still apply if the treaty does not expressly consent to arbitrate claims with dual nationals. And I just wanted to make one point, and I think that we cannot say that a national and a dual national are the same under international law. And I think that's one issue that has to be recognized. They have different treatment under international law. You can be a national, but if you're a dual national, certain specific rules apply to you as well. So just by the fact that the definition of national is interpreted accordance to domestic law does not mean that the dual national definition under international law should not be taken into account.
And then one last question here. Second, where'd it go? And this is a question for you, David Orta. Is Orta's argument stronger where the bit lacking a bar against claims by dual nationals was enacted post-ICSID, when that drafting option became broadly known?
Wait, can you say that again?
Is your argument stronger where the bit, which is silent against claims of dual nationals, was enacted post-ICSID convention? You know, when the drafting option became broadly known.
I would say it's equally as strong, because if the principles that David and I are advocating for purposes of this debate are applied, that shouldn't make a difference.
Well, I think with that, we'll wrap it up. I apologize if I didn't get to all of your questions, but I want to thank both Team David and the well-dressed team over here. Thank you so much. Again, it's everything that I